Anyone who follows the news will know of the trial of Felicien Kabuga. He was alleged to have played a major role in the preparation and execution of the 1994 genocide against the Tutsi in Rwanda. For over 20 years, since 1994, he was a fugitive until his eventual arrest under the International Residual Mechanism for Criminal Tribunals. Now, despite the overwhelming evidence of his guilt, he can expect never to have to answer to any of the grave crimes of which he is accused. We spoke to the mechanism's chief prosecutor, Dr. Serge Bramatz, to ask why and how both he and his office felt after all the work they had put in bringing Kabuga to justice. So thank you very much indeed.
Yes.
Can you hear me all right?
I can hear you, yes.
Good. Thank you very much indeed. I can imagine that this has been a very busy period for you. So thank you very much indeed for finding the time for us.
My pleasure.
So could we start, if we may, just if you would tell us what has happened, what is happening now, and what is next?
Well, those are already three questions.
Yes.
I'm just back from, as you know, longer mission to Rwanda and then to South Africa. My colleagues continued to Eswatini and Mozambique, very much in relation to the more recent arrest of Kaishima, where, of course, I went first to Kigali to meet the survivors, the victims at Nyanje Church. It was important for me to meet them after this important arrest. I had my meetings with the Prosecutor General, of course, with the Inspector General of Police, with the Minister of Justice, to thank all of them for the excellent cooperation we had in having this fugitive arrested, at the privilege of meeting your president, where I could also express the appreciation for the fantastic support we are getting by all operational services in Rwanda. And from there, I traveled to South Africa first, to Cape Town, where we had a one-day meeting with the task force composed by all operational services from South Africa, which has been extremely helpful in having the fugitive arrested and to discuss some follow-up investigations that need to take place. And then we were in Pretoria to meet with the Minister of Foreign Affairs, the Minister of Justice, DPP office, also to really thank for the support. As you know, cooperation has not been easy all the time over the last 3 years, but at the end of the day, it worked very, very well. So yeah, that was a bit my busy last few weeks, and we continue preparing for the transfer of Kaishima in order to make sure that his trial can start in a not too distant future.
So precise on Kabuga, especially legally, just for anybody who has not followed it, could you tell us what has been decided, how and why?
Yes, the Kabuga situation obviously is a very complex one, with, as you know, a recent decision which unfortunately was not what we had hoped for and what the survivors and victims had hoped for. As you know, after the arrest, which we all know was a very important achievement, the trial was since the day one very much impacted by his health situation. He could not be in court every day. We had only a few hours of trial every week. There were a number of medical reports made. In the beginning, some reports were in support of the continuation of the trial. Others were more critical. And the latest reports really, where the three experts agreed unanimously that he was not fit anymore to stand trial. That's why the trial judges decided by majority to not continue with the trial as such, but to have the so-called trial of facts, which would have been an alternative proceeding. One of the judges disagreed. He was of the opinion that the trial should continue. We appealed, and also the defense appealed this decision. We wanted mainly that the trial continues, as we were of the opinion that his intellectual capabilities were still sufficient enough to follow a trial. Well, of course, we are not doctors. We can only express our personal opinion on what we have seen in the courtroom. All this was submitted to the appeals judges, where the 5 appeal judges came out with their decision only 2 weeks ago, and basically suspending the proceedings for an undetermined period, and sending the case back to the trial chamber in order for the trial chamber to work on those indefinite stay of proceedings and to look into the issue of possible provisional release.
Right. Now, essentially what that, in layman's language, is that what awaits now is to have him released.
It's a bit more complicated. I saw in the media that some types were saying, well, tomorrow he's working out and he can choose wherever in the world he's going, right? The situation is much more complicated. You know, there have been other fugitives who, for example, after having, or persons who have been convicted after having served their sentence, they cannot decide wherever they go. In principle, in general terms, if someone who has been convicted in a third country or has been released or has been acquitted, in principle, this person goes back to its country of nationality. So the most logical consequence would be, as he's a Rwandese citizen, that he will go to Rwanda. Now,
what is the likelihood of that?
I don't know. It will not be my decision, but I would say in normal terms, someone of whatever nationality released or after having served a sentence or being acquitted in Belgium, in the US, or wherever, after the person has no legal status anymore in a country, the person has to leave the country. So the status Kabuga has in the Netherlands is that he is detained by the United Nations. So he can only be released if there is a country which is accepting him on its territory. So a country, the only country which is legally obliged to accept him is his country of origin. In this concrete case would be Rwanda. Now the alternatives would be that he would ask on humanitarian grounds to be accepted on the territory on the third country. Now we all know that he was hiding in France with a fake Burundian passport. Again, it's up to other countries to decide if they want to take him back on its territories. But I don't think it will be easy. It will be up to the defense, I would imagine, to make a number of démarches to see if a so-called third country would be willing to take him. And I'm expecting that this will take some time. And in the meantime, he stays detained in The Hague.
So is it fair to say that he's now no longer expected to answer for the crimes of genocide for which he had been charged, for which you had caught him?
This is correct. The trial proceedings have been suspended indefinitely. He remains an accused, and he will be provisional released. And wherever he is going, whichever country he is going, this country has to provide certain guarantees to the mechanism. We'll have to report on a regular basis to the mechanism. And it is indeed very unlikely that proceedings will ever start again, as one cannot really expect. One can still hope, but I don't know how realistic it would be to expect that his health situation will improve such that proceedings could resume.
But legally, technically, the door is still open for him to be charged with these crimes.
Very theoretically, but let's be realistic. Let's not create false hope. the most realistic analysis is obviously that having seen his health situation deteriorating since his arrest, it is indeed very unlikely that the mechanism proceedings will ever resume.
So you started by describing for us the very busy few weeks or days that you've had going around thanking an awful lot of people that were instrumental in you being able to bring him to justice, or at the very least, doing your part to bring him to justice. Let's turn to you personally, because you worked extraordinarily hard to track him down, often with a number of countries, and it has to be said, countries in Africa, getting in your way, having given him various false passports and so on. And eventually you did bring him to justice, only to have this happen. So how do you personally feel as a prosecutor who's done that amount of work, and you had prepared your case, you are convinced that it was fit to stand trial, and you've been hit by this? So how does it feel for you?
Well, it is obviously not what we were hoping for, but let's say that it will not take away that his arrest was a very important achievement for international justice. I remember the day of the arrest. I got many phone calls from friends, survivors from Rwanda, former and current prosecutor generals, and other friends I have in your country. And everyone was saying, we had really not expected that this individual would ever be arrested. So I think it is not taking away the fact that the arrest of Kabuga was an extremely important achievement. And since the first day of his arrest, the health issue was somehow an obstacle we had to overcome. Am I happy with the situation? Of course not. I've met often enough survivors. I know what it meant for them to have him arrested and what it means for them that those proceedings are not going on. Now, as prosecutors, we had already led the majority of our evidence in the courtroom. There have already been many individuals which have publicly testified about the crimes for which he has been charged. So the historical record about what those witnesses have testified is there. The evidence is there. The case file is there. Of course, it's extremely frustrating that at the end of the day, there will be no conviction. But, I'm working in this field for the last 30 years. We had many successes, but also a number of failures. The arrest of Kabuga was extremely important. Now, the current situation is not satisfactory. The arrest of Karishima was a major achievement as well. And, when I'm in Kigali, there are still more than 1,200 fugitives at large. And what the situation of Kabuga really shows is that time is against us. We need more support by more countries to have more fugitives, more genocidaires arrested, because many of them are getting older, and the longer it takes, the more difficult it will be for justice to be delivered. So we are not as frustrated as we may be. Well, the fight for justice needs to continue, and we will continue working with the Prosecutor General in Kigali and with the other colleagues and friends to make sure that other fugitives are arrested and prosecuted. And the clear message I'm giving to all capitals, because we know that out of those more than 1,200 fugitives, many of them, half of them are on the African continent, the other half are in Europe, in the US, in Canada, and Australia. And we are giving very clearly the message to all countries to say, well, you have the moral and legal obligation to extradite those individuals to Rwanda to have them prosecuted. And if ever, for whatever reason, you are not able or not willing to extradite those individuals, well, then you have the obligation to prosecute them before your own jurisdictions. And we, as mechanism of the United Nations, as residual mechanism, as former ICTR, we are absolutely willing to support any country to have genocidaires prosecuted, as we have more than 1 million pages of documents in relation to the genocide against the Tutsi in Rwanda. So the fight will go on. There will be many procedures to come, and we are ready to help Kigali and other countries to pursue the remaining cases.
Now, you're only an officer of the law. You have served the law for pretty much all your adult life, and your disappointment in this case, as in the others you have had, as you've mentioned, will be measured, and you will take the ups and downs within a broader perspective. So, but let's have a look at it from the point of view of the people whom, as a prosecutor, you'll have been in a way serving as well as serving the law. And those are the survivors, and those are the people that drove you to go and do the work that you did in bringing these people to justice. Would you accept their feeling that international justice has failed them pretty miserably?
You know, I absolutely understand their frustration, and I'm saying it always, also quite publicly. The only person on this planet who have really the right to have high expectations and to criticize are survivors and victims. I experienced this many times in relation to the Tribunal for the former Yugoslavia, where I worked, as you know, since 2008. I met more than 30 or 40 times survivors and victims, and they are very tough with us. They are very difficult. They are very critical. And the same when I was in Kigali. The colleagues from Ibuka are very critical with us, and I accept this criticism because they remind us every day why our tribunals have been created, why it is so important that justice is served. So I fully accept the criticism. I understand their frustrations, but as you know, we are, and my team, believe me, my entire team worked very, very hard to achieve what we have achieved so far. Everyone is disappointed and frustrated. So yeah, what can I say? I accept the frustration. You know, the international community failed the victims the first time by not preventing the genocide of happening, right? This, I would say, was the biggest failure. When we as prosecutors come in, it means that humanity has already failed. It already means that prevention has failed and that crimes have been committed. What we are trying as prosecutors is to be somehow the spokesperson of survivors and victims at the international field. In the Security Council, complaining if countries are not providing the support necessary. We are collecting evidence to get genocidaires convicted in court. Once we have managed to get them arrested, but again, we cannot be successful every time, and as frustrating the current situation is, unfortunately, we have to accept medical reports as reflecting the reality of a medical situation, and as unhappy as I am as a lawyer, there's nothing I can do.
It's not for me to make the judgment, but looking at, for anyone looking fairly at the work that, of course, your predecessor, but especially the work that has been done since you became chief prosecutor, there has been no let-up in the amount of work done to try and bring these people to justice. So from the survivors' point of view and those who wanted you to succeed, the reality is that you've done your work as they can see it, but the international justice has failed them and to some extent failed you too. Now, they draw a clear distinction with what happens with the Nazis who are caught in their 90s often, and they also always claim poor health, but the trial always goes on. And they draw this distinction and say there's one rule for the West, for Europe, and another rule for Africa. What would you say to that, if anything? It's a difficult position for you, I understand.
Yeah. No, look, I of course very much disagree with this conclusion. I think the Tribunal for Rwanda was put in place by a Security Council where African countries are represented. It was located in Arusha. The majority of judges, majority of prosecutors, of people working there are all from the African continent. So it has really been African justice delivered by Africans in support of victims of the African continent. So I think it would be too simple now to say, well, it's a double standard. The Nazi trials were happening in a different way than the Rwanda trials. I would say that more than 90 people have been indicted by the Rwanda tribunal. When I took over a few years ago, there were still 8 fugitives. We have been able to resolve 5 of the fugitive cases in the last 3 years. So as unfortunate the current situation may be, believe me, the standard the judges of the mechanism have used now to somehow end the proceedings is very much the standard which is supported by any country at the UN level. So I really don't think that this comparison is fair to say that because it is Africa, that medical analysis would now suddenly have a higher importance or lesser importance than in other parts of the world. But again, there is nothing I can do if people think that they have to make this kind of comparison.
But you do see the comparison. For instance, I mean, pretty much every one of these very much older former Nazis, 194, 195, always claim to suffer from ill health. That has never prevented trial from going ahead. And there is also a layperson looking at this, the decision to discontinue this trial was not anonymous, as you pointed out. One judge, Mustafa El-Baj, made the specific, let me read this here. He said, on the contrary, I am convinced that Kabuga retains a number of capacities which allow him to reach the legal standard at the legal standard out in jurisprudence. Now, if one judge thinks that, feels that, it then puts a question on the decision on which the other judges based theirs. Because one judge, and you, of course, you had also looked at this, you can't all be that wrong.
Look, I, of course, fully agree with the dissenting judge, right? I mean, he was fit enough to be a fugitive for so many years. He was living in a small apartment in Paris. And when he was arrested, of course, I have since day one been of the opinion that his trial can go on and must go on. And I read all the different medical reports as the judges did. And I was personally of the opinion that he was still capable enough and understanding enough of the proceedings to have this trial going on, especially as he has a very competent legal counsel, a lawyer, who was absolutely in a position to give him the necessary legal advice to have those proceedings going on. So my personal opinion is very, very clear on the issue. But, you know, once you work as a prosecutor in a court of law, you have to accept legal decisions by judges. That's what's, you know, that's the difference between us as who are applying humanitarian law and the genocidaires who are acting outside any legal framework when they commit their crimes. So I have to accept the final decision by the appeals judges. And I can also, even if I disagree, I can fully understand the reasoning, and they followed very much the reports put forward unanimously by all medical experts. So as much as I, as a prosecutor, who of course is one party in the proceedings, as much as I disagree with the findings, I have to accept them as the decision by the authority who is competent to take a final decision, and that's the judges who were very clear in expressing their opinion, which now needs to be implemented.
Absolutely. I mean, you have to follow the law as it is. But essentially, the layperson, as I say, can look at this, look at the work that you've done. You would not have taken a case to court that you did not think was worth taking to court. A judge said that this person should continue, the case should continue against this person. So the layperson can say, this is a technicality.
I think it's more complicated than that. I think no one has ever questioned the merits of the case. You know, when in '97 the arrest warrant was issued by the Rwanda tribunal, when after his arrest we had an amended indictment which was confirmed, and I'm absolutely convinced that all judges considered that the merits of the case, and that it was definitely a case based on the evidence available already, which needed or justified judicial proceeding to start and to move on. And, you know, at the end of the day, it is based on the medical findings where the judges were of the opinion that he was not, his intellectual capabilities due to the dementia were not putting him in a position to make sure that his rights as an accused are fully respected. And you know, the judges even invited all three experts during several days to court, questioning them, asking them dozens and dozens of questions, because obviously the judges in first instance wanted to be very, very sure about their decision. So just to say that I fully understand the frustrations. I would have preferred that the trial goes on. We appealed because we were of the opinion that he still, despite recognizing that there were obviously medical issues, we thought that it was still possible to move on with the proceedings. But again, I can intellectually fully follow the reasoning by the appeals judges in their decision, and there is nothing we can do about it. We have to accept it, and we'll continue even working harder on the many remaining cases.
It has been rejected, of course, but could you explain to us this other route of trying the facts, as it were, and what that might have meant or would have meant?
Yeah. You know what? The alternative proceeding, which was decided by the judges in first instance, two of the judges decided in favor of the alternative proceeding, which is so-called a trial of facts. It would mean that it's not a trial where at the end of the day there can be a conviction, but only kind of conclusion. The advantage would have been that the trial would have continued, all the evidence would have been heard by the trial judges, and they would have come up with findings, with conclusions at the end, at least having conclusions about the crimes committed in relation to the victims and survivors, much more recognizing their status as survivors and as victims. It is a procedure which had never been used at any international tribunal. It would have been a novum. It is used in some domestic procedures on an exceptional basis. So we thought that it was the second best option in my office as well, because we fully understand that when you speak about criminal proceedings at the domestic level, and even more so at the international level, the accused is very much in the center of the proceedings, which is quite logic. It is about his individual criminal responsibility. It's about his freedom. It's about him being convicted or acquitted. But I think personally that at the international level, it's not only about the accused. It is very much so about the thousands and thousands of survivors and victims. It's about the historical record of the genocide. It's about the administration of justice. That's why we were of the opinion that if you put everything in balance, while respecting very much the rights of the accused, we thought that this trial of facts at least would still recognize a larger space and place for survivors and victims to see, at least at the end, conclusions by the judges which would recognize much better the suffering they experienced. But again, it has never been used at an international level. It is exceptionally done at the domestic proceeding. And, well, you have seen the arguments by the appeals judges why they were of the opinion that the statute of the mechanism would not support.
You, your team, and everybody in the office are professionals, and you'll continue to go on. You mentioned that you now look forward to the other cases. But nonetheless, it must have been dispiriting for your team. And I mention again the huge amount of work that went into bringing Kabuga to trial. How is the team feeling, and what is the mood within your office?
You know, as I said, the tracking team was really mainly responsible for having him arrested, right? It was very hard work. As you know, we had cooperation with many different countries to finally locate him in France. And it was thanks to this international cooperation that he was arrested, right? We put a team together who prepared the prosecution, who started the prosecution in court, which led a number of witnesses. And of course, they are disappointed, they are frustrated. But you know, we are professionals. We know that all our career is composed by successes and failures. And we, as disappointed as we are not letting this impacting on our motivation to continue doing the job we are doing. I have next week a senior management meeting with all my senior colleagues. We are discussing how to move forward because it also means, with this case now ending, that many people will have to leave the office. And at the same time, we know that we still have an important mandate to fulfill. And as I said, when I was in Kigali, meeting my colleagues, the Prosecutor General and many others, there is so much work which still remains to be done. You know, we started a project together with the Prosecutor General. I went through the last 2 years through all our databases in Arusha to look at all evidence we have gathered in relation to individuals which were part of the investigations in the past or have been mentioned in judgments, in any of the many dozens of judgments, as members of a joint criminal enterprise without having been prosecuted. I identified close to 100 names of individuals for which we have collected evidence. We are now discussing those names with the Prosecutor General's office in Kigali. Some of them are not alive anymore. Others have been convicted in the meantime. But we also identified a quite important number of individuals which are still under investigations, where we can provide assistance in terms of evidence. And many of them are fugitives in third countries as well, where we will continue providing support to the Prosecutor General's office. So we will not have this negative experience impacting too negatively on our motivation to continue fighting for more justice, for more victims in relation to the genocide against the Tutsi in Rwanda.
In the very few minutes we have left, Dr. Brammertz, could you give us a very short summary on the fugitives that remain? Of course, there are, just so that we're clear, there are parameters where you can work. I mean, for instance, some people might say there are these people in the UK, for instance, who are living out in the open, but those are not within your remit. So there are some that are and some that aren't.
Yeah. I mean, there are 3 remaining fugitives on our list. As you know, are they still alive? Well, we have reasons to believe that 1 or 2 of them died in the meantime as well. But the main focus now will be to support the Prosecutor General in relation to his many fugitives. And as you are saying, there are a few hundreds of them are in the DRC, in certain areas which unfortunately have been the theater of conflicts for many, many years, where we are not very optimistic that arrests will take place soon. But we know that there are many others in African countries, in South African, East African countries, living there under fake identities. We know that a number of them are living quite openly in Europe and other countries where obviously more political pressure and discussion is needed to have them arrested and extradited, or to have them prosecuted domestically. And as we see now with the case of Kabuga, time is playing against us. It is today more urgent than ever. And with the 30th anniversary coming up next year, I hope this will be a reminder for everyone that the injustice cannot continue in the sense that it is so important that remaining genocidaires are arrested and prosecuted. As I said earlier, I was in Yaoundé. There were more than 30 survivors I met. We spent a few hours together. They were telling their stories, and it made me so aware that perhaps for other people, with all the conflicts going on in the world, they think that the genocide in Rwanda is more a historical event. Well, I'm always inviting everyone to go to Rwanda to speak with survivors, and they will see that for all the survivors, since they lost their loved ones, since those days in July '94, they are having nightmares. They are missing, of course, their loved ones every day, and their life changed dramatically since that day. And it is very often only the hope which keep them moving on, a hope for still a better life, but also for the hope to see those fugitives arrested and to see justice being done. And this is our mandate. We are motivated to continue working in this direction. And as I said earlier, there's still a lot of work to be done, and we will continue working with our brothers and sisters in Kigali to achieve this justice for more victims.
Dr. Bramat's Zoom time is against us as well. So thank you very much indeed for your time.
You're most welcome. Wish you a good day.
Thank you so much.